Hi everyone, how are you? I've got a lot to cover today. And I want to front end this because I don't want people frantically, trying to keep notes. I have just released a paper on October 4 called Well Broken, the End Game for the Anishinaabe Nation. So that's not a very promising title, but it goes into 23 pages of details and supporting aspects of what I'm about to share with you today. I'm also going to share a little more than what's in there, but I really want to start this by saying, anyone who wants a copy of that document directly from me, my email is switlo, SWITLO, @hotmail.com. Just put in the subject Well Broken, and I'll know to fire you off a copy. It will be up on my website soon. I don't know exactly when yet. My website is www.switlo.com. Remember, there's no W at the end of Switlo. It's important, of course, to know where things have come from. But I say to you today, the urgency, where things are at today, please focus on that. You need to survive now, this moment in time. You can go back and fix up the history, you can go back and correct things, but you need to be here first. And Canada has been very, very clever. And a close family member who's very familiar, of course, with my work, and I often will bounce things off the person, really summarized it well. That, and with all due respect, you're sitting on great wealth, you don't know it, and you're giving it away. So everyone has been taught to focus on, let's go somewhere, let's go ask this, UN, government, politicians. What's critical right now is what you can do, what you can show the international community, not what others will say about you. You need to have your voice directly. And the problem is that too many people are purporting to have your authorities and to speak for you, and actually go so far as to say this is how it's done under Anishinaabe law, when it's in fact under Indian Act. And it's disturbing what I have to share with you. So I really can't apologize. I do have to inform you as to what's really going on here. I had to laugh, Terry. Thank you for that. We quit killing them. And in terms of discussing the Treaty of Niagara, and said it was kind of like a peace treaty. Well, it wasn't you guys waving the white flag. It was them. And that we quit killing them. Well, that's always been an embarrassment. The people, Her Majesty's subjects, His Majesty's subjects now, have always been upset by these things. And it's racially based. You're beasts of the field. You shouldn't be entitled to have these things. You never were evolved enough as human beings. We should be well past that today, but we're not. We've had the residential school settlements, we've had apologies, and guess what? Instead of stepping back from the unlawful and unconstitutional interference with your sovereign governance, it's been stepped up. It's even more. And sadly, we don't have Indian agents now that are at the forefront of this and making things happen. It's your own people. And that's what makes it all the more difficult, because they're saying no more nations. The only thing we have left are successor Indian Act bands, and all the powers in a chief, an Indian Act defined chief, not an Anishinaabe leader, but an Indian Act chief. And they can do anything they want without your consent on anything. And maybe sometimes band council, a quorum of however, a couple of people, will be involved in that. But again, you're left out, and you've been taught to accept this Section 35 indoctrination language. Oh, consult us. To heck with consult us. the power rests in the people. You never had one king or queen who could sign anything away. And in fact, under Anishinaabe law, holding your allodial title, you could never sell, no one could ever sell it. That's your law, and the law of the land is where the land is. And I will talk to you in a few minutes here about what Canada is doing. You know, I reveal a lot of stuff, and Canada works hard to counter it. And Canada has been very, very clever. And I'll give them that. This is a really tough situation. They've come up with a way to do things that, quite frankly, has me scared. Not only for you, not only for Anishinaabe, but for all Canadians. So let me start. There's a couple of here's what I'm going to be discussing. The annuities cases done by representative plaintiffs, the Doctrine of Estoppel, that's now the new strategy, the strategy of treaty interpretation, as well as the Doctrine of Effective Control. The Robinson-Huron Treaty of 1850, everyone knows about that annuities litigation, but what maybe people don't know is that the Anishinaabe could not come together into a clear decision of how to proceed. Elders were warning, you need to do this under our laws. And what was being proposed did not create any sense of decision under Anishinaabe law and ways of doing things. So the lawyers, according to Mike Ristol, who is on the litigation management committee, said, well, what do we do? The lawyers came and said, hey, we have a way to get around this. Because we can't get agreement under Anishinaabe law, we've got an idea. And this idea was, okay, we don't need everyone's agreement. We'll set up a trust. We'll put in originally 17 chiefs. Don't need the people agreeing to this. Don't need band council resolutions. Just the chiefs at a meeting saying, okay, let's do this. Whereby they'd set up I call it the rhtf, the fund. And they're the trustees. And remember, they call it a trust indenture. But in Canada, when you have a formal trust indenture, you have professional trustees. There is no Canada Trust, there's no actual formal, experienced trustee, independent trustee to protect these monies that have been put in. And guess where these monies have come from? Are from the bands. Those are collective assets. And if a band council or a chief is exceeding the normal sort of day-to-day kind of operations of the band, any extraordinary use of money, the people have to approve that. No one approved that. Mike Ristol comments, and you'll see where I'm getting this from in the paper. It's a YouTube video of an interview that he did. He says, yeah, it was hard for them to all come up with the money. Again, no consent by the people. So what was this new way of doing it? And it goes further. It says, not only is this the new way we're going to do it, we're also saying this is how it's done under Anishinaabe law. That there's no nation, there's only the Indian Act bands. This is how you're described in the litigation, and you're all just, status Indians. There's no talk about who you actually are of the nation, of these things. There's no, it's all structured to say that as a nation you're gone, that the authority rests in the chiefs as representing the Indian Act bands, and the money's to go to the chiefs. But it gets worse, because there's 22 trustees, 21 from so-called, from bands, one for those who aren't in any band. But you know what? Hard to get instructions to lawyers from 22 people. So this new way of doing things is that they delegated their authorities under this trust agreement. It's not an indent. It's not a formal trust in that sense. And they delegated it to a litigation management committee consisting of 6 people. That committee is who retains and instructs the lawyers and runs this litigation in that sense. And they act by way of a quorum of 3 and can make decisions by 2. So pretty easy then for the lawyers to control where this goes, particularly if you read in my paper Mike Ristol's interview, or watch it on YouTube, the link's there. You'll see that after what, 10, 14 years involved in this, he is not able to clearly articulate what's going on. There is a major case that is relevant that he's trying to discuss. I lay out important terms from that case. This problem of, and here's how it works then. You have representative, not a class action. They're not getting it certified, because certification of class action, the damages, the awards would go to individuals. And they, most importantly, can opt out to say, that doesn't speak for me. That doesn't bind me. But they want it binding. The feds especially will agree and consent to a representative action, provided it's not certified as a class action. Why? Because that then purports to bind everyone. They are saying on behalf of everyone that, you know, this is all that's left. It's only Indian Act bands, and all the power sits in the chief. So these representative plaintiffs, the lawyers, of course, start up the action. There's another one now in Treaty 1. One person is the representative plaintiff. And lo and behold, no surprise, the province and Canada agree. That's cool. We're not going to contest that. So everything goes forward on a consent basis. Because what Canada knows full well that that's not under Anishinaabe law. I'm talking now the Robinson-Huron treaty litigation, which, by the way, that settlement offer, it came from that litigation management committee. So it's either 2, 3, or 6 people instructing lawyers to make the offer of $10 billion. I was surprised myself when I finally saw the settlement agreement documents, because it really came across like the offer was made to them, to you, quote unquote, but it wasn't. And he describes that not only were they being paid at sort of half rate, but also there's a contingency agreement. So that means that if this is done, the lawyers get a big chunk. Contingency agreements can go from 10% to 40%. So don't have a copy of that, so you don't know exactly how much. But of the $10 billion that they've proposed, I suggest there's a little self-interest there on behalf of the lawyers. Especially since, all the expenditures and disbursements and half rate salary. I mean, if they're charging $500 an hour, half rate's still $250 an hour. And in the Ontario Court of Appeal decision in the RHT 1850, the court said, no, we're not approving that for costs. They said more than $9 million. They said, no, that's going to have to go back and be proven, because we're not approving those costs. So there's been a lot of money paid, and like was described in his interview, Mike Ristol said, this has been a lot. It's been tough, but the people don't even know about this, and this. It's hard for me to talk about this because it is very upsetting. The way everything is being so basically, let's get a person, a couple people, let's roll them into court, let's slap in a contingency agreement. They say they speak for everyone. Does this sound like Anishinaabe law? Not in the least. And Canada knows full well. But So normally I would be able to drive a truck through that kind of stuff. But here's what Canada has come up with. And they announced it not long ago. They're applying this in everything, in specific claims, in land claims, in settlement agreements for litigation. They're using the equitable law, the Doctrine of Estoppel. And I explain exactly all of that in my paper. But essentially, here's what it means. And normally, estoppel is a doctrine that in a defense someone raises. So, you know, someone would challenge, for instance, a settlement agreement, and the court would decide whether the doctrine of estoppel should apply. Estoppel is basically a law of fairness, if you will. It arose where there'd be petition to the crown, to the king or queen, to say, you know, the courts can't handle this. The rules are too strict. It's not a matter of fairness. So there's this whole other asking for the king and queen to interject and say, no, this would be fair in the circumstances. That's not justice under common law. So the king can change that. And it eventually developed, there's so much demand on that, it developed into a separate standing court, and it still applies. And here's the big thing. Estoppel is also a key principle in international law. Why is that important here? Because, of course, as nations, as sovereign nations, as landowners, as defined under Anishinaabe law, not under Western principles of land ownership, you have that's your arena. You have access to global diplomacy. And parties in that area don't go into the courts of each other. They will use things like, they'll use their diplomatic best efforts. If they need help, they'll have friends, facilitators, mediators, and sometimes arbitration. And even then it's not binding, because it's all intended to help them come to an agreement. But remember, you already have recognition of your sovereignty and ownership. It's already clearly there. So using this principle of estoppel, normally to rely on it, Canada would have to have what's called clean hands. Can't have done anything dirty. So I would say Canada knows full well these are misrepresentations taking place in this litigation, knows full well that this is not how Anishinaabe law is, knows full well there's still an Anishinaabe nation, it's not just Indian Act bans, knows full well that the Indian Act unlawfully and unconstitutionally interfered in your governance, in your sovereignty, that the king recognizes. None of that is lawful. So it would be easy then if someone were to go into court and say, no, this whole litigation's a bunch of BS, it can't bind us, blah, blah, blah. And then Canada would try to rely on, Ontario would try to rely on, when I say Canada, I'm saying Ontario and Canada in terms of the Robinson-Huron litigation, would say, well, yeah, the response would be, you don't have clean hands. You knew damn well this was wrong. You knew damn well this was an effort to kill off a people, to take their land. You knew full well. Then court, and consider international arena, would be able to say, yeah, no, that's not how you can do things. That's an act of war, right? That's not reconciliation, as this is being termed. So so that's what it would be like if it was left to a matter of courts, if you will. But it's not. Canada is insisting that estoppel be put into the agreements themselves. What that means is that all the chiefs and band council resolutions, and they say, yeah, we speak for everyone, that you can't ever, no Anishinaabe, because remember they're speaking for everybody, no Anishinaabe national can ever raise that we're still here, that we still own, because the agreement says you're stopped from saying anything different from what's in the litigation pleadings, from what's in all of the settlement agreements. It's a heavy, heavy matter. You're silenced completely. And it's in everything now. So Canada says, well, yeah, in, for instance, specific claims, we used to always insist on a surrender, and people don't like to do that. So we're going to, and I've always said I could drive a truck through that, because the way it's been done through process, not even giving full information, not having proper level of vote, of consent, that the surrender under a specific claim isn't valid. It's void, ab initio, from beginning. So by putting that in there, they get away with no worries that someone like Switlo is going to come up and say, no, you didn't get a surrender. You didn't meet the standards. The king sets the standards. And Canadian governments can't reduce those standards. It doesn't matter that Canada said, for instance, you only need 25% plus 1 to put a land code in place that incorporates you and creates you as a company under a province. I'm sorry. There's so much, just rolling in here, and I'll lose my train of thought or place at times, as I've just done. So the point is, by putting it in those agreements, they don't have to rely on someone challenging what's been done, because it's saying no Anishinaabe can challenge what's been done. Why? Because the chiefs have said, this is Anishinaabe way. The chiefs have said, oh, there's only Indian bands left. The chiefs have said, yeah, we get all the money, and we get to decide, the chiefs get it personally. And if they want to give some to band members, that's up to them. But there's nothing enforcing that. See, under a certified class action, the court has to look at the proposal for settlement and decide whether that's in the best interest, if it's fair. So there's a role there. When it's not certified, when it's just a representative action, it can all proceed by consent. So now, the 2 out of 3 people who are instructing the lawyers on the advice of the lawyers can agree with Canada and Ontario and get some money. And that's why I caution you. It's really easy to get money in terms of giving up stuff. But you know what? With this situation, $10 billion offer, the going rate for land claim settlements, which is a giving up of sovereignty and title and all that stuff, would be about $100,000 a person these days. So if you have a band that's 7,000 people that are one band out of the 21, that's $7 billion just for that one band if they proceed under a land claim. Now times that by, I don't know all the membership numbers for all the 21 bands, but it's a lot more than a total of 10 billion. So, if you're gonna do that route, where you're going to abandon, you're going to give up and say, yeah, Canada's better, let's go under Canada, then it doesn't make sense to do it on this kind of litigation. You might as well just go under the federal policies and provincial policies of final land claim settlements, because you'll get more money if it's just about money. And that's the problem I want to focus here, is saying, if you start talking about, what was done with money in the past, and how do we get these trust accounts, and how do we go to the UN, and you know what, if you only got money in your heart, it's not going to work, because that's not what Anishinaabe is about. Yes, surviving. Your land is there, your gifts from the Creator. That's all to ensure that just like for thousands of years already, you'll still be here. Your next generations will still be here. That's what Anishinaabe law is about. So to focus on money, be clear that if you focus on who you are, what you have, still sovereign, still protect your land. The fact is that, for instance, any mining that takes place, they need your direct permissions, because the king holds permissions under treaties personally. They're not assignable. They're held personally. He can mine himself, for instance. And why I'm talking mining, because critical minerals is going to lay waste to land. He can mine himself. his governments of the Dominion of Canada can mine for him, and Crown corporations can, but not third-party companies, and certainly not foreign companies. They don't have any, there's nothing for them to rely on under the treaties. They need to get your direct permissions, but you know, they offer a pittance. Oh, here's some promise of jobs that, by the way, is not enforceable, and peanuts, literally. If they want your permissions, if you're agreeable, still your decision. If you're prepared to allow them to develop and mine and take of the land, then they need to pay you fair market value, and it's under the conditions that you dictate. You can do this here, there, in this way only, and you must do this. And you get it directly. This is not by a band or community level. This is by Anishinaabe level. If the nations are gone, if you are agreeing that there's only Indian Act bands now, then the only thing you're going to get are these Section 35 consultation and accommodation, which is these anemic impact benefit agreements. If, however, you are here as a nation, this is your land to protect and your land to benefit from. That changes over time. And that's all within your control. But of course, there's so much indoctrination and so many people don't believe that, and they think 10 billion is a lot of money, and it's not. You know, in this question, what's wrong with our lawyers? Well, the lawyers are doing it this way, using Section 35, using, as it was admitted, to get around Indigenous law, around Anishinaabe law, doing it through representative action, because they can't otherwise get into court. Treaties are not justiciable in domestic courts of one or the other party to them. It just doesn't work that way. You would laugh to say that, you know, a treaty between China and Russia, that Russia would go into Chinese courts to say, hey, you know, you owe us something here. That doesn't happen. But you have been indoctrinated, and it started through residential school, and this is why the title of my paper says Well Broken. It was English in the Victorian times, in 1850s. It was still the case that English believed they needed to break their children. They would start at a very young age. That's why such young children were taken to residential school, because the same philosophy was being used there. We need them obedient. We can't have them have any will. We need them to do as we dictate. We don't have to tell them why. They have no control, no consent. And by the way, it's even worse because they're not even humans. If we treat our children that we recognize are humans in this way, even more so when we're speaking of those seen as not human. So that philosophy, and it was successful, let's be clear. It's also been successful with the lawyers. They're indoctrinated the same way, that you're not a nation. You know, that, well, if we want to make this big money, and there's lots of money for lawyers to be made in this, I don't regret a moment of not being part of that. But the fact is that people who are motivated simply by money will do whatever it takes to get that, and we have examples of this. And they believe this is the only way to do things. And because they often stand to personally benefit greatly, they'll become very hostile if that's threatened. So it's important to know that, and that's what Terry pointed out, you know, this acting independent of each other, that supports that the only thing left is Indian Act bans. The greatest danger, the Supreme Court of Canada will be hearing the Robinson-Huron Treaty 1850 litigation appeal from the Ontario Court of Appeal. This is a huge opportunity. The part that gets me really upset about this is a couple of people just doing this to impact everyone. So the big thing, and of course, these people that are involved in this litigation, they're just, oh, we won at trial. Yeah, not a peep about the Ontario Court of Appeal decision. It's a 300-page decision. I have gone through that decision and I have highlighted all of what is at risk. Nobody's telling anyone about that. Just, oh, look at us. We're doing so well and now we're going to get $10 billion. That $10 billion is a, uh-oh, I feel, as with my legal background, uh-oh, we're going to be in trouble. We better grab something now. We might not get it later. And you'll notice Ontario isn't, no one's, that just emboldened Ontario in its appeal. No one's moving forward on that settlement agreement. And they won't. They'll wait for the Supreme Court of Canada because, there's going to be some clear precedents set. When the decision is at the Supreme Court of Canada level, that applies then across. That means that it'll be used against all treaties, against all nations. So there's a heavy burden on Anishinaabe nationals. The consequences that will fall from threatening all these nations, I won't even speculate. But anyhow, the treaty interpretation, the arguments, and the decisions of, because there weren't unanimous decisions in the Ontario Court of Appeal, which is why there's an ability to appeal to the Supreme Court of Canada. Certain justices would point out about treaty interpretation, and they're using statutory interpretation cases. What they're saying now, because remember people, I have talked about how the treaties recognize your sovereignty, recognize your ownership, to have and to hold. That's clearly a lease, hold interest. And in 1895, this Supreme Court of Canada, which was then the Privy Council in England, decision speaks of, and the arbitration that happened before that, that's all pertaining to Robinson-Huron Treaty 1850, speaks clearly that the Crown has a fee prior to Confederation, and that the title of the Crown did not change on Confederation when we have the provinces coming together and forming things of 1867. Well, and also says these treaties are Canada. The Solicitor General J.J. Curran says these are matters of international law. This is in the 1895 treaty. And what's a fee? A fee is an estate. It is not allodial title. The Crown has allodial title over in England, and through that allodial title, estates which are not the land itself, that's like paper representing, but it's not actually land ownership. It's always beneath the Crown's ownership. You have that here. You have allodial title. The law of the land is your law. And you granted permissions to the Crown, and the highest court of the land in 1895 said, yeah, the Crown got a fee. But no one's talking about that because everyone going into this litigation is saying that you sold the land. And the Supreme Court, because no one's challenging, everyone's agreeing. Everyone's saying this is the 1850, that was a sale. And the Supreme Court of Canada is going to confirm that was a sale. Where, here's the unique thing about that treaty. It doesn't list the Anishinaabe nation. It's individual chiefs and headmen who are parties to the treaty. Most treaties, you have the Crown as one party and the nations as another. In this particular treaty, you have individuals. So what are they really bargaining for? It's the individual's use of Anishinaabe land under Anishinaabe law, not the underlying allodial title. It's just a sale of an estate. And everyone's like, well, gee, you know, they used to get paid. Those chiefs got paid once a year. Then suddenly that stopped and it changed. Well, guess what? The chiefs died, right? So the landlord who's giving permissions to use their Anishinaabe land interest, it's like a you know, every nation has a system of land use. And so the fact that you permit this family here to be in control and quote unquote own under Indigenous law this area doesn't mean they can actually sell out the land. That's clear in your laws. You can't sell it. But if you're sitting in this farmhouse and a Canadian, an English person comes along and says, gee, I'd sure like to live in there, that person can say, sure, you can have my house, you know, but just, you know, I'll rent my house to you. After those chiefs died, suddenly people were receiving, you know, now $4 per person. That was Canada just trying to say, oh, we still have this, trying to put in place what's called a de facto, a treaty-like arrangement, that if you accept those payments, that means you're recognizing that there's still a commitment there, that the Crown, well, the governments of Canada did this, not the Crown, that they can still rely on this. But it's not very secure, and all sorts of interests have piled up on that, when the fact is you still own it all. So isn't that convenient to have this litigation go forward, which everyone agrees, remember those two people, everyone agrees, oh yeah, total title was sold, you don't own any of it, you just have the reserves and you're just going to get some annuities. That's why these chiefs are saying, oh, that's Anishinaabe way, the chiefs get the money. That's not Anishinaabe way. That was individuals agreeing to rent their personal usage that's allowed under Anishinaabe law, and that's it. But the Supreme Court of Canada will confirm, and you can't stop this thing. You know, the horse is out of the barn, as I say. The Supreme Court of Canada also has 19 interveners. Some of those interveners are groups, all on the Indigenous side, if you will. Well, I'll say the Indian Act side, because they are, you know, all Section 35 stuff. It's the same old stuff. So much so that Ontario was made application to say, you know, and these are, do we have to respond to every single one? Can't we just do one reply? And the court looked at it and said, yeah, because that basically signals they're all saying the same thing. So you got all these lawyers charging to do the same, make the same representations. And of course, what does that do? It bolsters the end result that Canada can say, yeah, it's a sale, because everyone going in there is going under Section 35, which says you have no allodial title. You're just Section 35. So if you look at this, the Crown did not follow the doctrine of discovery when entering into treaties. The kings and queens did not, they ignored the doctrine of discovery. Instead, they recognized your nationhood, your sovereignty, and your land ownership. That's critical to understand. What does the doctrine of discovery come into place? Section 35 incorporates the elements of the doctrine of discovery. But now you don't have to say it's the doctrine of discovery. Now we have a new title. It's called Aboriginal Right of Aboriginal Title, the Section 35 Domestic Doctrine. And everyone loves it. Everyone's going in and saying, yep, that's right. This is how we do things. And representative plaintiffs, yep, that's right. We're no nations. Never were. This is our only hope. We're now under Canada already because we're just Indian Act bands. And you have other lawyers that will write about how, oh, you know, the Indian Act was, you know, put in place to administer and govern the bands. Excuse me? I set out in the paper how what's not in your treaties, what that means. There's no giving up of sovereignty and handing over of governance that you see in things like treaty from New Zealand. And I set out the specifics. So what's happening here? Well, to have and to hold, for example, clear terms of there's no way to say that's not a lease when you see those things there. Well, Canada's new domestic law is saying, and using statutory interpretation, which statutory interpretation applies to all laws. So really the exercise that the domestic courts have to do now, and they will be allowed to use statutory interpretation applied to treaty interpretation that says, well, the intentions today is a reconciliation. So we're going to, for our purposes, because remember we're in domestic courts, we're going to determine that we can ignore, for instance, to having to hold. Because these Indians are here, they want to reconcile, they want to come under, they've accepted Section 35 doctrine, and on it goes. Why is this so scary? Because if they can do that and create this new domestic law, there is nothing stopping the courts from doing that to a provincial law that's passed. We don't like it. Remember, the judges are appointed by the politicians here. They're not independent. So, you know, you can't stop a law from passing in a legislature or the parliament. Well, just haul it into court and say, you know, those words can't be interpreted or relied on. Here's what we're really trying to do. And so the court can then dictate what the law is. This is not a matter of, oh, what they wrote is confusing, so we need the court's help to figure out what was meant by those words. We're talking here now clear words, where there's no question what those words mean. The court can still, based on trying to do you in, do every single aspect of democracy in Canada. And that is something that Canadians don't realize. Back in 1997, in my book, Gustavson Lake Under Siege, I ended it saying, so who's next? Well, it's continued. And we'll end up then with a dictatorship, an oligarchy of judges that are hand-selected by prime ministers and by provincial bodies as well. That's a really clever way to destroy the treaties. And the courts will say, hey, that's okay because you've come under the court saying you're not a nation anyhow. And only nations can have treaties, so they're not really treaties. So it's okay for us to say what they are today. Under this concept of estoppel, where I maybe have repeated this, but I just want to emphasize that you could take, as an actual nation with these treaties, you could go to the international arena and say, look what Canada's doing. This is incredible. This is a coup. This is an act of war. There's all sorts of ways to talk and trigger what's wrong with this picture. But not with those estoppel clauses in. The settlement agreement, the estoppel clause. And it doesn't matter how much of the litigation is left. They get one of those that binds Anishinaabe, and when those other countries come calling to Canada and say, what the hell are you doing? Their nations, no, actually, estoppel, they agreed to it. They can't say that. International community then says, oh, okay, see ya. They can't get involved. It's a very clever trick. The other way that, and I've forgotten this part, the other process is increasing the power of chiefs and councils. Courts saying, if it's a matter of land claims in BC, never mind that there's hereditary chiefs and such, under their particular laws that they direct and control, you need their decisions and input. The courts say, oh, no, it's just chief and council. If there's going to be some consultation under Section 35 doctrine, it's just with the chief and council. You don't have to talk to the people. They'll speak for the people. So different ways that the courts have, and I've laid out some of those in the paper, that the courts are basically saying, you only think, and especially when you go into court and say, yeah, it's only Indian Act bans now, we're gone as nations. So the courts are loading up on what chiefs can do, on what band councils can do, leaving you completely out of the picture. That is not the Anishinaabe way. The other aspect is the Doctrine of Effective Control. This is where Canada doesn't need something signed by you. This idea of prove, where'd you get the title? There's all sorts of ways that Canada can say to the world they now have title. Mostly by your capitulation, mostly by your representations, mostly by putting a gag on you. The other aspect is this Doctrine of Effective Control, where Canada just passes laws and says, we're going to administer and control the water. You own the water, there's no water treaty. The proper way to deal with that, and why is water important? Because of critical minerals. Mining takes a lot of water. Green energy, hydrogen development actually destroys water. So water and drought, and what we're at, fires and all that stuff, water's critical. Who owns the water? That's your right to life. But Canada's saying, well, and I've pointed this out to the Crown, and immediately upon that, instead of saying, look, we need to do a treaty on this, a proper treaty, not a land claim, Trudeau comes back and guess what? Putting in place a national water board, a national, that's putting in place regulations and laws and saying just so it can say, yeah, we don't have the legal right, Crown doesn't own it, can't give that to Canada. Canada's just going to do it anyhow. That's not respectful. That's not removing unlawful interferences. That's doubling down. That's saying we're just going to take it. But yet, and that's why I call Canada an outlaw nation, because that can't be done. They can't just take. But everyone, guess what? Oh, here's some money. We'll go be consulted on the establishment of this national board. That way Canada can evidence that, yeah, see, they want us to do it. They're not doing it. And no one's saying, hey, I'm here to see what the heck you're trying to do with our water, and not because in putting Canada on notice, you don't have any right to this. It's got to be more than just me. So this Doctrine of Effective Control, how they're going to use statutory interpretation to change the treaties, how they're using the representations made about Indigenous nations in courts that says you're not nations anymore, all of this, treaties collapsing, nations collapsing, and you'll end up being just that domestic ethnic minority that no one has to pay attention to. And no one has to fund. No one has to support reservations. Because also, the treaties fall, those reservations are reservations out of treaty. Now Canada is just going to mow over that too if you don't have the protection of the treaties. So there you go. Like I said, there's a lot there. The document's 23 pages. Do please ask for it, and I'll let you know when it's up to. So thank you for your time.